Your manager just told you that you work in an at-will state, meaning they can fire you whenever they want, for whatever reason they want, with no warning and no explanation. That's what most employees believe, and most employers want you to keep believing it. Because at-will employment does not mean what most people think it means. There are exceptions that apply in almost every state, exceptions that your employer almost certainly never told you about, and understanding them is the difference between walking away from a wrongful termination and walking away from a legitimate legal claim. Over the course of this video, I'm going to tell you exactly what at-will employment means, what it doesn't mean, and the 3 exceptions that could apply to your situation right now. I'm a lawyer. I've worked through employment cases from both sides, representing employees who were wrongfully terminated, as well as advising companies on their obligations. And I can tell you that at-will employment is one of the most misunderstood legal concepts in the American workplace. Here's how to think about it correctly. At-will employment means your employer can terminate your employment at any time for any lawful reason, or for no reason at all, without being required to give you advance notice or severance pay. That's the definition anyway. Now here's what it doesn't mean. It does not mean that your employer can fire you for any reason. The word lawful does enormous work in that definition. Your employer cannot fire you for an unlawful reason, and the law defines unlawful reasons more broadly than most employees realize. When I evaluate an at-will termination, I ask, does this termination fall into one of the recognized exceptions? Because if it does, the at-will doctrine doesn't protect the employer, and the employee may have a claim. Now let's go through them. Let me be clear about what at-will employment does allow, because this part is real. Under at-will employment, your employer can fire you because business is slow, because they want to restructure, because your manager simply doesn't like you, because they hired somebody cheaper, because they changed their mind about the role, because of a personality conflict. None of these require explanation, and none of them are illegal on their own. They can also change your pay, your hours, your job title, or even your responsibilities, as long as you continue working there. The employment relationship is at will in both directions. That means you can also quit at any time without notice and without penalty. So, at will is real, and it is significant, but it does have its limits, and those limits are where most employers hope you won't look. Check out the following graphic for a reiteration of what at-will employment does allow. The first and most widely recognized exception is the public policy exception. It applies in approximately 43 states. The public policy exception says your employer cannot fire you for a reason that violates a clear public policy, even in an at-will state. What does that mean in practice? Your employer cannot fire you for filing a workers' compensation claim after a workplace injury. They cannot fire you for reporting a workplace safety violation to OSHA. They cannot fire you for serving on jury duty. They cannot fire you for refusing to commit an illegal act that your employer asked you to commit. They cannot fire you for whistleblowing, reporting fraud, violations, or illegal conduct. Check out the following graphic for a visual list of these public policy exceptions. These are all protected activities. Firing someone for any of them in a state that recognizes the public policy exception is wrongful termination, regardless of at-will employment status. The key evidence question in these cases is, what was the real reason for the termination? If you filed a workers' compensation claim on Monday and were fired on Wednesday with no prior performance issues, well, that timeline tells a story. Document it. The second exception applies in approximately 38 states and is the one that surprises most people. It's called the implied contract exception. An implied contract can exist even without a formal written employment agreement. It can be created by statements your employer made, policies in your employee handbook, or representations during your hiring process. Here is the most important application of this exception: your employee handbook. If your employer's handbook states that employees will only be terminated for cause or lists a progressive discipline process, verbal warning, written warning, final warning before termination, that handbook language may create an implied contract that limits their ability to fire you at will. Courts have found implied contracts based on handbook language in multiple states. If your employer skipped their own disciplinary process to fire you, that's worth examining with an employment attorney. The other major source of implied contracts: verbal promises. If a manager told you during hiring that we don't let people go unless there's a serious problem, or you'll have a job here as long as you perform, those statements can, in some circumstances, create enforceable expectations. The third exception is narrower and recognized in fewer states, approximately 11. It's called the covenant of good faith and fair dealing. In states that recognize this exception, employers cannot terminate employees in bad faith or for malicious reasons, even under at-will employment. The clearest example courts have recognized is firing a long-term employee just before they were entitled to collect a pension or a large bonus, specifically so the company could avoid paying it. That's not just a business decision. That's bad faith, and courts in these states have found it to be actionable. California, Massachusetts, Nevada, Montana, and a handful of others recognize some version of this exception. If you're in one of these states and were fired under suspicious timing, right before a vesting date, a commission payment, or a bonus, it's worth a conversation with an employment attorney. Here's your action stack. 5 steps in order. Step 1. Read your employee handbook right now. Specifically, the termination and discipline sections. Does it list a progressive discipline process? Does it say employees are only terminated for cause? If it does, your employer may have created an implied contract. Screenshot or save those pages. Step 2. Document every performance review, positive feedback, and commendation you've received. If you're facing a termination that came out of nowhere after years of positive reviews, that paper trail matters enormously for an implied contract or public policy argument. Step 3. Write down the timeline. When did any relevant event happen? A complaint you filed? A claim you made? Maybe a refusal to do something illegal? When did your employer's behavior towards you change? When were you terminated? That full timeline is the foundation of any wrongful termination argument. Step 4. Check your state's specific exceptions. I've linked a state-by-state reference in the video description. Find out whether your state recognizes the public policy exception, the implied contract exception, and the good faith exception, and which of those might apply to your situation. I've also linked a free wrongful termination checklist in the video description. It walks you through the key questions an employment attorney would ask about your situation. In the event you might have an at-will employment issue and you're going to consult with an employment attorney about it, that checklist will help you prepare for that discussion, so it's worth checking out. Lastly, step 5. If the timeline and the exceptions align, consult an employment attorney before signing anything your former employer sends you. Severance agreements almost always include a release of all claims you may possibly have against your former employer. Once you sign that release, you may be giving up a legal claim you didn't even know you had. Do not sign that until you understand what exactly you are releasing. Before you go, I want to hear from you. Have you ever been fired and wondered if it was actually legal? Drop it in the comments. I read every one and they shape exactly what I'll cover next. If this was useful, the subscribe button is right there on the top left. New video every Tuesday. And if you want to know how to actually fight back when someone wrongs you, not just understand your rights, but also how to take action, the next video is the full playbook on security deposit disputes. How to document, how to negotiate, and most importantly, how to win. That's next Tuesday. See you there.